It's my very great pleasure to welcome Professor Gerald here today. His paper, I think, is something that I think a lot of us will have different interests in, and I was not at all surprised, but very pleased at the breadth of ideas in here, because I think there's going to be something, hopefully, for all of us to discuss when we get this chance. So, without any more, thank you, Jerry.
Well, thank you, Nicole. It's a great pleasure to be here. My first visit to Singapore, I hope it's not my last. Certainly don't want it to follow in Anthony Scalia's train. So, the paper I sent on is directed to a really tiny part of a project that I've been at work on for, now I must confess, about 9 years. And I thought it might be helpful to give you a little bit of the larger scope of things before I focus just for a few minutes on the remarks that are in the paper itself. I began my interest in the work of Sir Matthew Hale many years ago, back now over 30 years ago, when I was trying to answer the question, why was Bentham so bent out of shape by the common law? I knew that he didn't like Blackstone's lectures in Oxford, but he was only 12 then, for goodness sake, and he should have grown up. And I wanted to know more about what the circumstances were, that is, what the history of this thing called the common law might be. And so I spent a good bit of time looking around and thinking about classical common law jurisprudence, as well as, oddly enough, David Hume. Then after the publication of Bentham in the Common Law Tradition in '86, I went on to do other things, and around the year 2000, 2002 or so, I went back to thinking about common law tradition again and did some work rather more broadly on that tradition, and began reading again and working even harder on Matthew Hale, at which time I discovered, or shortly after that, I guess, I discovered that there was indeed a manuscript unpublished of Matthew Hale's work on natural law. But I finished the work in early 2000s, published it, and then began thinking about this treatise, which he now calls Treatise on the Nature of Law in General and of the Natural Law. Never been published. It comes to around 120 folio pages. And after reading it through, especially the first chapter, as I was telling Nicole and Andrew today, my initial response was to go to the British Library and burn it, on the ground that it seemed to undermine everything I had said about Hale. And then I thought the better of it, because actually some people had already, like Michael Lubin and Alan Cromarty and others, had identified this piece of work already, and so it was not likely I could get away with it. And so I thought better to publish it along with other things, and so it could be, as in a larger totality, give a picture of Hale's rather broad and to a certain extent deep thinking about the nature of law. And so I put together a collection which includes the treatise, now the main part of it, and another work which had been published some years ago by Holdsworth back in the beginning of the 20th century, in a very inferior edition called Reflections upon Mr. Hobbes, His Dialogue, that is a critique of Hobbes's dialogue between the philosopher and the student of the common laws. Those two pieces, in a way, are quite different in their character and in their focus, but also give a distorted view, it seems to me, if we only had those pieces. So I thought to fill out that unpublished, or nearly unpublished part with some work that had been published since the 18th century, and one piece that was actually published in Hale's lifetime, the only piece that was published in Hale's lifetime. To give a kind of rounder picture of the jurisprudential thinking of this very important middle to mid-late 17th century English jurist. I don't think I have to say very much here to introduce you to Matthew Hale. He was, without a doubt, the most important lawyer of the period from about the mid-1640s to 1676 when he died. Sat on each of the three major courts as the Chief Justice of Exchequer and the Chief Justice of King's Bench, also sat on common pleas, and wrote enormous amounts of work, none of which was published, almost all of it written to my eye for his own self-clarification, including works not only on doctrinal matters, many of them, but also on the common law of his day and its history. The most important, of course, is called the History of the Common Laws of England, a very important document in the history of English law, and two major treatises in theology, as well as some work on magnetism and other things of that sort. He was a polymath. Today, what I'd like to do is give just a sketch of some of the themes, very, very brief themes, a sketch of the themes in the collection, and then look to a brief summary of some of the basic ideas of my paper on the invalidating power of law. There are two themes I want to emphasize here, one being the work, I call it his thetic conception of law, thetic coming from his own term, lawgiver, or nomothetes, one who sets out the law. On the one hand, his account of natural law and his thetic conception of law, and the other, his understanding of common law, and bring those into juxtaposition, and then go on to talk about the Potestas, Irritans, the invalidating power of law. So, on the first matter, in the opening chapter of the treatise of the nature of laws in general and of the natural law, within a few pages, Matthew Hale gives this definition. Law is that rule of moral actions addressed to beings capable of intellect and will by one who has authority both to give the law and to exact obedience. Not as promising start you would have thought for a common lawyer. Sounds much more positivist, and so many people who have read this have said, Hale was really a positivist. I want to say no, but I won't say very much about that today. But the reason why he introduced this idea, this definition of law in general, this is not about positive law, this is not about common law, this is not about just divine law, this is about law in general, very much in the style of scholastic treatises in the nature of law, predominantly Suarez's, but you could see the same pattern in many, many such treatises to give a general definition of law, with much the same shape. What he wanted to capture was what he took to be the distinctive feature of law, which is its directive power. And by directive power, he meant that the law does two things. It indicates that which is good to be done or evil to be avoided, but it also has a prescriptive side. And it is addressed to beings with intellect and will. That addressed to element, I believe, can be traced all the way back to Aquinas in his definition of lex. But you find it throughout the scholastic tradition thereafter. And the other part that's crucial here, he thinks, in order to capture the distinctive character of law, is that it necessarily generates obligation. That law is not just a matter of indicating something to be good and directing our attention to it. It is imposing an obligation on us. And he thought the only way to capture that is by thinking of laws as issuing from someone who has a certain kind of standing with respect to those to whom it's addressed. Obligation becomes important here. And for Hale, obligation is understood to be a relational notion. That is, to be under obligation is to be related to another party such that that which one is obligated to do is owed to that party, where that party stands in the relationship of having the power to hold the subject accountable for acting and behaving according to that obligation. So there's a relational notion that's built into his very idea of obligation. So what issues from this is a conception of law that has as its center what he calls the nomothetes, the lawgiver. It's not necessarily the law's author, it turns out, but at least has to be in some sense endorsed by or authorized by this lawgiver. Underwritten, perhaps we might want to say. So natural law on this view turns out to be a fairly typical scholastic version of a hybrid view of law. Namely, it's a combination of indicating that which is in itself and intrinsically morally good or, to be avoided, morally evil. Picking out those items in the, as it were, in the real world, real moral world. And then indicating or directing the action of those who are subject to it, to do it under obligation by someone who has the capacity to issue obligation. It's a hybrid view. It's not voluntarist because law is not defined in terms of simply the will of the lawgiver. Because the will of the lawgiver is directed towards those things that have intrinsic good or evil. Yet the will of the lawgiver plays an important role in understanding the law. So it has this kind of combination, hybrid character. So it's aesthetic, I want to say, but not voluntarist. Civil law, or what we might call positive law, understood within this context is, in Hale's view, instituted law. It's the product, that is, of human intervention and human invention, though not necessarily of human design or human enactment. But like his scholastic forebears, civil law is understood as something that emerges from the activity of human beings in their communities and is instituted by them. And there are various accounts of how that institution should go, and Hale develops one on his own. But the crucial thing here is that it is a human invention. Now, this civil law then is related to natural law by way of this idea of the permissive character of law, of natural law, or what he calls lex permissiva. So there is a domain in which, of natural law, in which the civil law is introduced and has and can play. And that domain is created by essentially the indeterminacy of natural law. And the indeterminacy has three sources. One is there are areas that are truly morally indifferent, what medieval philosophers often call the adiaphora, the indifferent, morally indifferent part. Then there is that domain of the moral world, which natural law orders in a good degree, but the details of it are left indeterminate. This is the domain that Aquinas would call the domain of the determinatio, where the natural law gives you general directives, like what's his example? Like the architect gives for a house, but then the architect's scheme must then be put to use by the contractor, the constructor, and the carpenter to build the house. It will have these various features, but what exactly those are going to be determined by the resources available and other such things. So there will be norms of natural law that will need determination. There will be some areas that natural law leaves uncontrolled, undirected. And then there's an area, it seems to be entirely, to my mind, Hale's own creation, but he calls those areas that are determinate by virtue of our reason. And what he says is he's very much concerned with, very much moved by the incredible complexity of moral life. Circumstances of moral life are constantly changing, and human interaction is a very complex matter. And while natural law may have some, in fact, determinate things to say about those interactions, nevertheless, working out those determinate answers may be very difficult, such that even those of us who are intellectually well-trained, we may come to very different solutions. Nevertheless, for the purpose of social arrangements, and especially in those cases where we need common and public rules with regards to these matters, and where we need to be sure that there's fairness in treatment across cases, that's the area where it's indeterminate not in its nature, but with respect to our reason. And there we need civil law to come in and make it determinate, make common public rules determinate. And so instituted law, civil law, has a place within natural law. Not outside it and not indifferent to it, but within natural law. Although it turns out that those areas that are indifferent with respect to our own reason might be cases where the public rules we come up with don't track nicely the determinate natural law should we be able to discover it. There's a possibility of there being a disjunction between them, and our public rules may nevertheless be justified by virtue of the need for common public rules. He says, sometimes the natural law is not made for common rules. And we living together need common public rules. So that's the three ways. And so within this domain of natural law, instituted law has a place. It's not separate from it. This is not a positivist picture, it seems to me. Although positive law plays a crucial role, it's not a positivist theory of law, it seems to me. So that's one side, pathetic side. On the other side, common law. Common law is common, he says, because, of course, it is the law of the whole kingdom. No longer the law of the Kents and the law of West Saxon, is it? But it is the law of the whole kingdom. But more importantly, it's common because it is congruent with and fits with the common constitution and the common life of the people of England. It's common law. This common law, he says, is really, there are two parts to it, the lex non scripta and the lex scripta. Lex non scripta, he says, is the substratum. It's that which is the foundation for, the substratum for all of law, and substratum for the governing power, if you will, the sovereign power, substratum of power. Where lex scripta is that enacted law, which exists now just in virtue of its being enacted by some recognized parliament. Lex scripta becomes part of the common law when it no longer rests on that, in his view, weak basis, and becomes incorporated into the common law itself. So the lex non scripta includes both enacted and non-enacted law. Enacted law has, as it were, its limited base, and it becomes law of England, if you will, by being incorporated into the whole body of the law, into the corpus juris, but also incorporated into the constitution, if you will, of the people. So there's a necessary congruency between the two. The formal and obliging force of this common law, then, is what he calls long usage or custom or the like. Acceptance, though he's quite aware that he's not talking simply about custom in the community. He is in part talking about custom in foro, if you will, and not custom in pes. The next important notion for his account of common law is the notion of practical reasoning. He distinguishes in Reflections on Hobbes, dialogue, between the reason in things, which he means rational ordering of things, and reason in us, which he means our reasoning faculty. And then he thinks there's a third kind of reason, which is a combination of those, where the reason in us, which is capable of deliberation and discernment and is discursive, that comes in contact with some domain of a rational order, but is the practiced grasp of that reason within a certain kind of community. So he thinks there is that special combination in mathematicians and in physicians and in lawyers. And so he picks this out and says, what we have here in the law, the common law then supplements natural law by introducing this instituted body of law and relates it to and is sort of maintained by a cadre of those who were trained in this special discipline of legal reasoning. That discipline of legal reasoning is then, of course, the domain Cook called artificial reason, the artificial reason of the law, which in Hale's view combines a secure grasp of general principles and a refined understanding of all the cases in which those principles have been applied, and a mastery of moving from one to the other. And thirdly, an acquaintance, a fluency, you might want to say, with what he calls human conversation. That is, the daily interactions of human sort of quotidian life. And each judge is then thought to draw from and contribute to what he takes to be a kind of common stock of determinations of this body of law, which is, it turns out, a common activity, mutually engaged, mutually drawing from, mutually contributing to it. So those are some of the themes you might find in the rest of the treatise and many of the works that I included in this volume. I want to talk a little bit about laws in irritating force. I don't mean tax law. It's in the United States, it's coming close to the 15th of April when we start thinking about the irritating power of law. So what I tried to do in this paper is to put together historical and philosophical reflections on a kind of weird idea, which I nevertheless take to be central to Hale's common law doctrine of law's sovereignty. And other work I'm doing, I'm spending a lot of time thinking about the rule of law and, as I call it, law's rule. And I think there is something to be learned from Hale here, or at least to reflect on. And he draws from two sources for this account. One is the common law doctrine. Not every common lawyer held this doctrine, but the common law doctrine by many, with its roots in Bracton, but many others, Cook and Hooker and others, in which the idea is all of governing power is, in the language I like to use, is ordained. That is defined and delimited by the law. There is no governing power except governing power that's defined by law. And so the king, at the apex of governing power, the king himself, the monarch itself, is subject to law. That's the core common law doctrine. And he puts that together with a scholastic, somewhat Roman law and canon law doctrine of what I call the three powers analysis of law. And those two together, neither of which are unique, are put together in a way that is uniquely Hale's, I think, in his way of understanding, if you will, this constitutional doctrine, this rule of law. The three powers analysis is an analysis of the defining features of law. Not three tasks of law or three functions of law, but three forms in which law, when it's doing its work, forms that law takes. Three different powers, effects, he sometimes calls it. And I propose in the paper to understand them in terms of three modes of normative guidance, using a contemporary term to help explicate what's going on. Three forms are directive power, coercive power, and invalidating power or nullifying power. The directive power I've mentioned already. It includes this indicating of the good or to be done or evil to be avoided, plus the prescriptive power, which addresses a directive to a party and puts that party under obligation. That obligation then being, if you recall, relational, and so requires that there be someone in place that can hold the party accountable, who is subject to that law, subject to that directive power of law. The coercive power, fairly straightforward. The one who is subject to the coercive power is liable to judgment and to remedy or sanction, and has an obligation to submit. And officials have rights to enforce. And then the irritating power or the invalidating power, and that's the power to withdraw or withhold legal recognition of some kind of act. Now, there are two problems or two questions arise with respect to this immediately. One is, what is this invalidating power? And the other is, how are we going to substantiate Hale's claim that the king, the apex of governing power, is nevertheless subject to the law? And his answer is, the king, the monarch, is subject to law's directive power, but not its coercive power. But it is subject to its invalidating power. And the question is, how do we understand this invalidating power such that we can make something of that, given that we understand that the directive power entails being under obligation? Now, in the tradition he's working in, from Aquinas on, this distinction between being subject to the directive power and not subject to the coercive power is, as it were, standard first year exam question, answer to an exam question. What is the sovereign What is the prince subject to? Subject directive power, not the coercive power. But the directive power also always thought to have obligation. Obligation just meant a matter of conscience. Obligation in foro interno. But there's no talk here about accountability. No talk here about answering to someone. So how are we going to get that into the picture? I suggest that we look at the invalidating power to see how that works. What is this? We meet a puzzle immediately because it looks like we've got Hofeld and Hart backwards. It's like all those critics of so-called sanction theories that they said they got, Hart said, you get the cart before the horse, right? We start thinking about law by thinking about what it does when you don't do it, right? It looks like this has it backwards as well. But now with respect to what Hart called power conferring rules, but now we're thinking of them in reverse, as it were with the cart before the horse. But also what's really interesting is that unlike the Hofeld and Hart and all that we from the 20th century on have thought of as the standard way of thinking about invalidation, is that it's connected to power conferring rules, to laws that create powers, and yet the long tradition that Hale's working in suggests that it's connected to prohibitions, to duty imposing rules. How do we understand that? And my first reaction was, being trained back in the 60s and 70s, that this was just a big mistake. And then I thought, well, wait a minute. There's a whole long tradition in which this is going on. We ought to think it through a bit more carefully. Maybe it is a conceptual mistake. Maybe we're mistaken to think that the concepts are as narrowly defined as that. And so I went on to think about how we could understand this as now a separate power of law that might be connected with power conferring, power defining kind of laws, but also might be some way or other connected to duties or prohibitions or the like. How could we make sense of that? So that's what I try to do with this paper. And one of the things I try to think about examples in which there might be something like laws withholding or withdrawing recognition of certain kinds of legal consequences of actions that might plausibly be connected to something other than simply the exercise of official or non-official or private powers. What kind of examples might come to mind? One possibility is that sometimes those powers that are assigned to officials or others are powers which one can abuse. So there might be duties along with the powers, such that if you violate the duties, there might be an interesting question whether the exercise of the power contrary to the duty has its normal, recognized, expected consequence in the law. And we might think that the law would sometimes withhold it and sometimes grant it. And it turns out that there are examples of that kind of thing. Maybe the continental doctrine of abus de droit, the abuse of right, is one such notion. The notion of estoppel strikes me as a possibility. Because if you think of estoppel as not itself a wrong, but doing certain kind of things that are within the framework of what one is entitled to do, but because you've induced the reliance of another party in a way, you may be denied the benefit of the withdrawing that promise or withdrawing that assertion or not counting on the silence or the like. Estoppel by laches, for example, doesn't allow you to take advantage of a late move in court to advance your rights once others have relied on your failure to do so. Another possibility is, as Simon mentioned to me, that there are, noticed in the paper, that there are constitutional duties that seem to have nullification as their primary consequence. The American Constitution says, Congress shall make no law infringing the freedom of religion and the exercise of it, and makes no law. Of course, it doesn't sanction that duty, There's no official sanction that goes along with it, but the courts have understood that to mean a ground for nullifying the laws that are in conflict with that principle. There's even a more starkly obvious example in the Venezuelan Constitution, where it makes it very clear it is a duty not to engage in certain kinds of lawmaking activities. But the example I found most compelling was the example of a license. Where you think of a license as an exception to a general prohibition, like the license, for example, that we give to police officers to use even deadly force under some circumstances, or to violate property rights by entering a home against the will of the owner, but only under certain conditions. So there's a general prohibition. The license is an exception to that, which permits that kind of action under legal cover, so that the actions are not subject to the usual kind of criminal or other sanctions, but only under certain conditions. And if those conditions are not met, the legal cover is removed. And under those circumstances, the actions of the officer without due warrant can be sanctioned. The action of someone acting out of self-defense when the conditions of self-defense aren't fully met can be, the justification of self-defense can be made not available to one. And so you get a picture of there being a certain kind of licensing with legal cover, which then legal cover is removed under those circumstances when the conditions are not met. And there's the key to figuring out what Hale has in mind. Because Hale's picture is the monarch is subject to the directive power of law, and so bound, obligation bound, but the sovereign is not subject to the coercive power of law, but is subject to the invalidating or the nullifying power of law. So if there are actions that the king warrants or commands of his, as he calls them, instruments, his ministers or his officials, if there are such commands which are inconsistent with the existing law, then while the king is beyond the scope of the law, the coercive demands of law, the directive part of the law still holds, and he's subject to that directive part. But the commands or will of the sovereign, which should have given legal cover to the officers, to the instruments, to the ministers, is removed. The actions are nullified, and as he says, no longer are the king's ministers indemnified for their actions. Dicey later calls it, they're legally naked. And so what we get here is a kind of accountability, not direct, but indirect, not on the king himself, but on the king's ministers, and so on what the king is actually capable of accomplishing, which he can accomplish almost nothing on his own. So we get a kind of legally defined, legally institutionalized accountability, not the kind of accountability that was often the worry of so many theorists in the 17th century, that is, accountability through violence. Locke says, under these circumstances, all we do is appeal to God, right, which means you go to war. And so we get an account of what could be something like an understanding of how the governing power can be, in all of its activities, subject to the law, and so an account of the law's sovereignty. That's the theme. Thanks.